with Jim and myself for the last, well, not quite an hour, I guess maybe about an hour. Sara, as you watch this, one of the things that struck me was this very methodical closing argument that the prosecutor put out there. She went through each one of the charges, actually said to the jury the order she thought in which she thought they should consider those charges. And she kept coming back to two phrases, common sense and critical thinking. How effective is it when a prosecutor approaches the jury in that way?
I think she was really effective, Erica. You know, look, the defense has been factually deprived in this case from the get-go, and McMichael's testimony did not help at all. That we saw a defendant become the prosecution's star witness. You know, he confirmed that there was no threat, that really the only threat were the three defendants committing multiple felonies that this prosecutor laid out very clearly refutes self-defense. You don't get to commit felonies and be the first aggressor and under the self-defense law in Georgia claim self-defense. And she also went through this methodically in terms of the analysis, right? Yeah. Because the first part of the analysis is the citizen's arrest. If you don't have a valid citizen's arrest, you don't get to self-defense.
So on that question, because that was also central to the prosecutor, Linda Dunikowski's closing argument here, she described the standards for a citizen's arrest as requiring a crime committed in your presence, which she says not met in this case, or that you had immediate knowledge of a crime being committed. She said, this case doesn't meet that standard. Now, there was a moment when the defense lawyer jumped up and said, wait, the prosecutor is not accurately describing the citizen's arrest law. You're a lawyer. Who was describing it correctly?
The prosecutor. I think the defense lawyer was, you know, sometimes we interject to sort of break up the prosecutor's momentum in closing arguments, but really she's correct, right? Because these guys proceeded on assumption. They said, oh, you know, February 11th, this might have been the same guy that was at this house. And we, you know, no, that is not immediate knowledge. They didn't know where Arbery was earlier that day, let alone committing a felony offense. And they certainly didn't see it. So she's very correct to say, you can't proceed on gossip. You can't proceed on hearsay. You have to have either seen the crime or have had immediate knowledge. 12 days ago is not immediate.
It seems like an odd, I mean, you point out, Sara, that this will happen. Maybe a defense attorney will try to disrupt the momentum for the prosecution. The judge, though, when that moment happened, said to the jury, didn't really weigh either way, simply said, the jury will have a copy of the law. If you're interrupting by saying that she's not accurate, and you know the jury's going to get a copy of the law, which you say is accurate, I mean, it seems like sort of an odd decision to make if that's where you're going to interrupt momentum.
It is, but remember, I mean, this is not the same lawyer, but we've seen another defense lawyer in this case make those frivolous, the black pastors can't be in the courtroom motions over and over and over again. You know, they're just grasping. They're grasping. This is an indefensible case. Honestly, I rarely say this, but it's a very difficult case for the defense. And so I think this judge is saying, this judge did not admonish the prosecutor. You can absolutely, as an attorney making closing arguments, break down the law, break down the elements, unless you're grossly misstating the law, then that's obviously going to be an issue with the court. But this judge would have told her she was wrong if she really was wrong. I think that I'm sorry for the interruption. I think this judge did not because she was correct. And he was basically saying, look, ultimately the instruction will come from me, and you are to use those instructions as the law that you're applying to facts.
Understood. And listen, we're about to hear the defense argument. Of course, we will bring that to our audience live. There was a moment in the prosecutor's argument that struck me as critical to the prosecution's case, and that was as she described what the accused, the three men accused of the murder of Arbery, brought to this, including the weapon. Have a listen to that, and I just want to see in your experience if you thought that was an impactful moment.
That's Travis McMichael pulling that shotgun up. Well, what are they going to tell you? They're going to tell you what Travis said. Oh, he was running toward me, and I could tell he was going to attack me. Is that reasonable? Who brought the shotgun to the party? Who took the shotgun out of the car? Who pointed the shotgun? The guy's running away from them for 5 minutes. Here's the thing, you cannot create the danger to yourself. That means you cannot be the initial unjustified aggressor. You can't create the situation and then go, I was defending myself. You just can't do it.
Impactful moment, and does she describe the law correctly there?
Absolutely, Jim, because look, he was unarmed. That's a huge fact, right? He was unarmed, he was running away. So who's really the threat? It's the defendants. One has a gun, one's threatening him, two are going at him with a truck. So the idea here is that also remember, she talked about this in the context of credibility. She said that initially, he had an hour to write out a statement for the detective and never mentioned that Arbery was grabbing his gun and striking him with it. And then suddenly he gets before the jury and these facts come out. Whenever a defendant or a witness adds facts over time, that's a big red flag that they're lying. And, we've got video here. We know exactly what happened. This was a guy who was running away from them. They had no idea whether he had committed a crime. They brought the gun. They used the gun. They committed multiple felonies. They were not acting in self-defense.
Sara Azari, great to have you with us as always. Thank you.
Guys.
As Jim said, we'll bring you the defense closing arguments too once those begin. Up next here.